So welcome everyone this morning. My name is Trent Levitt, and joined with me today is Kaylee Richmond. As we get started here, I'd like to start out by just saying I've done a lot of these. I've been doing these for 14 years, either through a webinar aspect or live. And I'll say up front, for some reason this morning, I'm a little more nervous than I normally am. When I could probably say I've easily done 250 plus of these, but for some reason I'm a bit nervous. So bear with me. As we get going here, looking at our agenda, I'd like to do a quick introduction so you get to know Kaylee and I a little bit more, and why we have some type of claim on the topic we're going to be going over today. I'm going to go through a quick disclaimer, and then we're going to start into our actual mock ESI, or electronically stored information discovery request. Now, the whole point of this is there's parts of in the discovery request of ESI that we see common flaws or problems, or the responses are not what they should be. We're not going to cover every aspect of a discovery request, but we wanted to cover it from the standpoint from the electronic discovery and the digital forensic expert standpoint. And then, of course, as we go through this, towards the end, we'll have any questions, and we're more than happy to answer any questions that you have. I'll be the first person to tell you I don't like to make up answers as I go. Typically doesn't bode well when you're testifying in court, so it doesn't go well in other aspects of my life either. So if you do have questions that I can't answer, I'm more than happy to do that research for you and then email or give you a phone call and get those questions answered for you that you may have. So from an introduction standpoint, again, my name is Trent Levitt. I'm the Digital Forensics and eDiscovery Manager here at Eide Bailly. And then joined with me is literally my left and right hand in the work that we do, and it's Kaylee Richmond. Kaylee and I have worked together now for just over 4.5 years. And I would say we're a fantastic team. And what makes us a fantastic team is I typically do whatever Kaylee tells me to do, even though I'm her boss. So it is a great relationship, and Kaylee and I have worked on a lot of interesting cases together, some of which we will be going over today. So a little bit about me. I do have a Bachelor's of Science in Computer Forensics and Digital Investigation from Champlain College in Burlington, Vermont. I am the co-founder of a company called Decipher Forensics that I co-founded in 2012. And then in 2018, we merged with Eide Bailly. Decided that selling the company was the best move forward in the industry that we're working in. And typically the work that we do is mostly with law firms, but we have worked with a number of law enforcement agencies from around the country. And for 4 years, I did teach cell phone forensics at Utah Valley University here. I'm based in Lehi, Utah, if anyone knows where that is. It's about 40 minutes south of Salt Lake City, if you're not familiar with the area. Types of cases that not only myself, but Kaylee has worked on as well. We've worked on homicide cases, kidnapping, stalking. CP is an acronym for child pornography. When we are out in public having lunch, it's not typically a phrase that you throw out. People start to look at you funny. So we usually refer to it as CP or CSAM. I worked on hundreds of those cases when I used to be a FBI contractor, and that was actually the reason I left the FBI contracting work, was that type of casework that we were doing. But we've done family law, missing persons. My personal favorite is intellectual property theft in all different forms. That is my absolute favorite type of case to work on. We've done corporate espionage, accident injury, actually some bankruptcy, and then lots of different types of litigation, construction, just being one of the types of civil litigation that we've worked on. And I've received training directly from the FBI, Idaho State Police, as well as SANS and several different software companies. Kaylee, I was actually able to, when I owned my own company with Decipher, I was actually able to, I'll say, steal Kaylee from a top law firm here in the Salt Lake City area. And Kaylee was an incredible find and helped fill a very big void that we had in our company at the time. So Kaylee's been working in the legal / eDiscovery space for 9 years. And then for the last 5 years, working in digital forensics. And Kaylee is our in-house cell phone forensic specialist. And the things that Kaylee can do with a cell phone are absolutely amazing. I will typically tell people that If you want me to really get to know you, or if you want Kaylee to really get to know you, just give Kaylee your cell phone for 24 hours. And we can usually tell your significant other something about you that they probably didn't know, whether that be good or bad. That's a common thing with cell phones. When we keep them so close to us all the time, we don't realize how much of our personality and our likes and dislikes actually go into that cell phone and what we do in it day in and day out. So cell phone forensics has always been a fascinating topic for me. And I know Kaylee shares the same love with it, but she is our in-house certified expert in cell phone forensics. So our disclaimer is, first and foremost, we are not attorneys. And we do not take the place of legal counsel, of course. And we offer our experiences in relation to the cases that we've worked on and the experiences, good or bad, that we've had with literally at this point, thousands of clients. If I had to tell you how many cases I've worked on to this point in my career, I would say I'm probably well over 2,000 cases in my career that I've worked on, either in a electronic discovery format or a digital forensic format, or a combination of both. So we always offer advice in all the cases we work on to counsel that has hired us. That's one of the reasons that they do hire us. But we always leave the final decision to counsel, and we just give our opinion on the matters that we're engaged in. And so today, that's going to be a lot of what we're doing, is showing experiences that we've gone through when it comes to dealing with electronic discovery requests. And regardless of what side of it, whether we're producing the request or we are receiving the request with the counsel we're working with. So with that, let's get into it. So before I go any further, one thing I was actually speaking to another attorney about yesterday. We kind of got off topic on a case we were working on, and he said, "What's one of the strangest things you've done in your career?" And if you know anything about computer forensics, that's a very loaded question. I would say I do something strange in my career about once a month. But I would say the strangest thing that I've ever done is I've actually written a search warrant that was then executed 3 days later upon myself. I've never met anyone that has had that same experience. I had a law enforcement agency that I have done a lot of work with, and there was a civil case that turned criminal. And so a professional phone call was made, given the fact that I taught this gentleman a lot of what he knows about digital forensics. And he said, I have a search warrant that I need to put together, but I'm not going to come in and raid your lab. He said, why don't you write up the way the search warrant should look, so I can only take what I'm supposed to take and not anything more than that? To which I was very grateful. So I literally wrote up the search warrant. He changed a couple things on it, and 3 days later showed up at my lab and executed the search warrant on me. It's one of those things I will probably never experience again, hopefully never experience again in my career. So when I look at civil litigation, I look at it as a form of war. Not in a bloody battle, of course, but civil litigation to me is a battle of intellectual mindset and war. That's what makes the legal industry so interesting to me. So war, the highlighted term that I have there, is the art or science of warfare. And I really find that to be true because we are playing a mental game so often with the things we know, some things that are assumed, but hopefully not too much. And we're playing a back and forth game based on what we know. And one of the favorite books of mine is The Art of War by Sun Tzu. And the first time I read this particular piece right here, when I read it, really captured my attention. And I just thought, well, that's the legal industry. That's so many of the cases that I work on. But the part that stood out to me the most was there at the bottom: attack him where he is unprepared and appear where you are not expected. So often when Kaylee and I are hired to work on cases, we are literally that last sentence. We attack where people are unprepared, and we absolutely appear where we are not expected, and always to the benefit of our client. And I don't say that from a sales pitch standpoint, but there's so many things that we do within computer forensics and electronic discovery that will give our clients the edge in the cases they're working on. You know, a lot of people refer to Kaylee and I as hackers, and I'd be the first to tell you that I'm not a hacker. I don't try to break into other people's systems, as it's commonly known, but a hacker in the sense of a hacker will simply use artifacts, will use tools for something other than its intended use. And that's what the true definition of a hacker is. So we will absolutely use artifacts on cell phones and operating systems and servers for something other than its intended purpose, and we use it from the standpoint of it being evidentiary. So as we move through this today, there'll be a number of things where that will come up, but in every case we work on, we look at it as if we were going to war. So the whole point behind this was we've gone through lots of discovery requests, and we've helped put out that discovery request for our clients in assisting on the electronic data portion of it. And we've also received many discovery requests, and we've helped walk our clients through the best way to respond and collecting data and things of that nature. But it wasn't too long ago that we received one, and it was actually, for the most part, I would say is probably one of the best ones I've ever read from the standpoint of receiving it. And the attorney that we were working with, he said, I'm really going to lean on you and Kaylee for this so that I don't get this wrong. And I don't have many attorneys say that to me. So as we started to read through it, and Kaylee and I were taking notes and discussing it, it was very interesting how well done it was. And as we talked to the attorney, I just said, look, there's been obvious help from an expert in putting this together, and there's very specific language. This was very well done. So we had to be very careful, and Kaylee's taken the lion's share of this work in this particular case that she knows I'm talking about. So it made me go back and look through a number of the discovery requests that we've worked on. And I wanted to pull out some of the things that typically get overlooked or aren't responded to in the correct way. And that's what I want to address overall today as we go through everything. So this right here, within 30 days of the entry of the order, the parties will exchange the information listed. On the surface, that's really not a big deal. And I would say that most counsel would say that 30 days is a reasonable timeline to do something like that. But there's a number of items and things to take into consideration before you would agree to that and say that, hey, the 30 days is perfect, almost a thank you for the time. And one of those is, how organized is your client? I've dealt with some very organized companies, large and small, and I've dealt with some very disorganized companies, large and small. And that 30-day timeline, we have run right up to the end of it because of nothing else but the disorganization of the client in certain matters. Other things to consider are the number of custodians involved. And then internally, are there people to help? Is it the size of a company, in a civil matter, where there might be someone internally that can help pull and organize the data or give us access to the data? And that makes a big difference in the amount of time that it takes as well. Another consideration is the location of the data. Do they run completely in the cloud, for example? Or are they partially in the cloud, and then they have one location where they might have an on-premise server, and then everyone works from just a single location? Or to complicate things even more, do they have 15 locations in 15 different states? And then how do we go about collecting those? Now, technology has come to the point where a lot of the data collections that are done remotely. We don't have to go on site like we used to, but there's still the coordination of making sure that people are on their network and those things can be done and be available when we need to collect and make sure that they're there. Kaylee, can you talk just a little bit, and I'll introduce Kaylee here. Can you talk just a little bit from the standpoint of just trying to coordinate with 8 to 10 people, in 7 or 8 different locations And from your standpoint in running the majority of the collections, just to start on this first part, how difficult that can be at times.
Sure. On a case that I'm currently working on, there's only like four people that I'm trying to coordinate with.
Mhm.
It has taken us about a month just to get the emails collected. And within that month, the IT department that was pulling together the 22 custodians email accounts for us, there's a miscommunication because the data is enormous and there's no way that's only 22 custodians.
Oh, this is the one we spoke of yesterday.
Yes, it's the one of the four that I'm coordinating with informed me that the amount of data is over 1,000 terabytes, which is a petabyte of data, which is huge for only 22 custodians. So I think he might have pulled all the email accounts for the entire organization, for the entirety of the organization being a business. So we're coordinating again tomorrow to see what might have happened.
Okay.
But that has been about a month since the case started, just to get to this point.
Okay. So a number of things to take into consideration there. You may say, given the size of the matter or given some unforeseen circumstances that we're expecting, we would appreciate it if we could do this within 45 days or even 60 days as we get things started here, just so we're not putting undue burden and stress upon people like Kaylee and myself, upon yourself and your own team, and then especially upon the client as well, that obviously has to be involved in this. So the written description of the steps the party has taken to preserve likely relevant electronically stored information. When I read this, I thought, well, this is loaded. Someone knew exactly what they were asking for when they made this statement in the discovery request. And on one hand, I was kind of proud of them because it's something I would have put in there had I been putting it together. But it reminded me of one, and I had to go back and find this and pull the exact language. So this was a smaller case, but this was literally the language used. I typed it verbatim. Requested my client to copy all emails from email account relevant to case to an external drive and provide to me for review. One of my favorite things to do is have data thrown out of the case. And that's what I thoroughly enjoy doing, especially when the counsel that I'm working for tells me that is really damaging to my case, what they just tried to bring in. So what I look for are reasons and ways to legally and ethically have that information thrown out. And I always consider it a big win when I can have information thrown out that was trying to be brought in. I don't always win at it, but I've had a number of wins in doing that very thing. When you start responding with this type of language and not taking it seriously, then I'm more than likely to win that argument, in working with counsel to have whatever it is you tried to pull in, whether it's language or emails or a thumb drive or a cell phone, whatever it might be. I'm more than likely going to win that argument in front of a judge or through counsel in front of a judge. So the first thing we need to do in relation to showing how things were preserved is step one is we need to identify what it is that we're working with. And this is really simple. Sometimes when people say, well, we have to conduct interviews, it almost sounds intimidating. But the interview can just be a phone call and just having a list of questions that each custodian, obviously starting off in the request, each custodian named in the case would need to answer. And a lot of times it's about the nature of the matter at hand, but more than that, when we're talking about electronic information, it's questions about how the custodians communicated with one another in relation to the matter at hand. And we have to be specific, because if we're dealing with savvy opposing counsel, they're going to be specific. And if we're not, then that's when the arguments can start, as anyone that's dealt in that will know. So we can identify from a quick custodial interview, for example, that the custodian has a laptop, a cell phone, has an email account, and a cloud account where data was shared and or communicated. If I could take that a step further, the cell phone opens up a whole different array. And it's one of the areas that when Kaylee and I consult on new cases, it's one of those items that is commonly overlooked, because they say, well, the cell phone is private, they won't release it, or they're going to get upset if they have to give up their phone for a day or two. Those are all things that can be easily overcome. But the cell phone, in many of the cases we work on today, and this has been a progression over the last 4 or 5 years, the cell phone becomes such an integral part of the case, because not only are there call logs, and we obviously don't know what they talked about, but we can establish that calls were going back and forth between parties or other custodians, but there's text messages obviously involved with that. And then third to that, if we're talking about any type of communication, and I've seen discovery requests where they even throw in carrier pigeons just to make sure they're covering all their bases, which gets ridiculous. But if you look at third-party apps, we can communicate through Facebook Messenger, through Instagram, through Snapchat, through WhatsApp, and the list just keeps going on and on and on. If they ever communicated through any of those apps, then we need to know that. Because if they bring it up and we say we did our interviews and those things weren't brought to light, but opposing counsel's clients say that, well, we did use Facebook Messenger to communicate, then we have to be ready to collect those things. And then the questions can come up of why those weren't disclosed in the first place, because it did say all communications. So the cell phone, in a way, can become kind of a Pandora's box for good or for bad, depending on where your case sits and which side of the case you're sitting on. But from this identification, a lot of these are pretty self-explanatory. The laptops, the cell phones, the thumb drives and external drives, those would tend to get people. We'll take possession of a laptop, for example, and we will specifically ask for any thumb drives or external drives that have been plugged into, laptop A within the last 90 days. And then no thumb drives or external drives are produced when we do the data collection. One of the things that happens when you plug in an external drive or a thumb drive is there has to be a relationship there. The thumb drive and the laptop have to talk in order to share information and pull or send information back and forth to one another. What it typically will record is when it was plugged in, the make, model, and serial number of the thumb drive or external drive plugged in. And then a lot of times it will show a file path or a file name of something that was accessed or possibly even copied from one to the other. So thumb drives are something we usually typically go back and we'll say, you said there were no thumb drives or external drives, but within that 90-day period, I have 3 different devices here that we would like to take a look at and collect in the matter of this case. Social media is already a big one that we've talked about, and then cloud accounts. And cloud accounts can be anything from a Gmail account to obviously a Google Drive account attached to it, Dropbox. And Kaylee does the lion's share, if not all, of our cloud-based account collections. Kaylee, how often would you say that the cloud accounts provide very relevant data that could have easily been overlooked?
70% of the time.
Yeah, I would agree with that. I was going to say 60 to 70%.
Yeah, it's right in there somewhere, thereabouts.
So we just finished a case a couple weeks ago where the literal communication was taking place in Google Drive. And what they were doing is they would go in and type a note on a Google Doc. They would type a note, with a question mark, and then the other person would immediately just start typing. And they were just typing back and forth, almost like a chat session, but on a Google Doc. And that entire Google Doc became the overwhelming piece of evidence for this particular case we were working on. So in identifying everything, this becomes crucial, again, in the interview process, and just knowing what questions to ask and making sure we don't forget anything when it comes to electronic forms of communication. So step 2 of that original question in the steps taken, step 2 is preservation. And the preservation of data, it can be as easy as telling your client not to delete anything. On a very rudimentary, archaic level, client, don't delete anything. It can get you in trouble. It can lead to sanctions. It can, it can cause more problems than you want to deal with, on top of already being in a litigation case. We did have a gentleman one time, opposing counsel's gentleman, in a case I worked in. I'm just going to say in Kentucky, because I never say the actual areas that I worked the case in. So I had a gentleman in Kentucky, and I flew out there. I took possession of his laptop, and I took possession of 2 cell phones. And he had already received a preservation letter, and we'll get to that preservation letters here in a moment. And when he handed everything over to me, with a very smug look on his face, he smiled at me, handed it to me, and he just said, "Happy hunting to you." And the client I was working with, I know, didn't have a lot of money, and this was already very expensive for her. And I just thought, well, I'm the owner of the company at the time. I was the owner of the company. I just thought, I'm going to do what I want on this. And because of that one comment, I put an extra, I don't know, I think it was like 17 or 20 hours worth of work into that case with no charge, because of that one comment. And what I was able to find in that bit of pro bono time that I put into it was that after receiving the certified letter of preservation, 2 days afterwards, he was deleting everything pertinent to his case that we needed off his laptop. Presented that to counsel and put it into a report. Had a conversation on the phone with the judge about it, and both counsel on the conference call. And we actually went to trial on that case. And not only did the judge tell the jury in that case to hold prejudice against opposing counsel's client for that, they also put a $15,000 sanction on him as well. And ultimately, he ended up losing his case for that and lots of other reasons. So preservation is vitally important. But when I'm talking to my clients about preservation, the best form of preservation is simply to forensically collect the data. So data collection, and I hope this part is informative to you. This is where we're going to spend the majority of our time overall today, is on the collection of data. And here's the reason why. So on the law enforcement side of the work that Kaylee and I will do, very rarely do we run into any issues with the proper collection of electronic data in criminal cases. The majority, I won't say all, but the majority of law enforcement officers that work in computer forensics or have any type of training will understand what they can and can't do with a cell phone or a hard drive, a computer, whatever it is that might hold data from an electronic standpoint. When you flip the page over on that and go to civil litigation, it's literally a 50-50 shot on whether or not the data that we're going to receive, and sometimes from our client or from opposing counsel, is going to be collected properly. I've had numerous situations where I've had information given to me by my own client, and I will say, I can't work with this. This was not collected properly. And their question or their comment back to me is, well, this is what we have to work with, so you're going to have to work with it. My answer is no, I don't. You can go find someone else that's willing to cash in their career on one case. I'm not willing to. If it's not properly collected, again, as I said earlier, it's not a hard argument to have that information thrown out of court. And the vindictive side of me actually has a fair amount of fun doing it, because these are all things that should be known. And if you're consulting with a proper outside vendor, they should be doing these things properly as well. So this is something that we're trying to change. And on a national level, there's been a number of changes over the last few years to help move this along so that that 50% moves up closer to that 99% from the comparison of civil to criminal with electronic information. This is 100% especially true when it comes to mobile data. And there was I don't know a lot of case law. So if you find this impressive, don't, because it's about the only case law that I know, because it's the only one in the last 7 or 8 years that's really had a big impact on my day-to-day work. But there at the bottom, Riley v. California was a case that Riley was a gentleman in California that was arrested in a traffic stop and related for drug charges. They took possession of his cell phone and they started to go through his cell phone, which is not good to begin with because of the way they did it. But what happened from that is they implicated Mr. Riley in several other crimes, and then they were able to tie other people to those same crimes, and a number of people ended up getting arrested because of what was on his phone. So Mr. Riley fought that, and it actually went to the Supreme Court, and in a unanimous decision, which I don't think that happens much anymore, a warrantless search and seizure of a digital device, digital contents, they said was unconstitutional. So from 2014 on in the criminal world, anytime Kaylee or myself are dealing specifically with a cell phone, we have to have a search warrant attached to the cell phone we're working on because of that decision. And part of me says rightfully so, and part of me says not rightfully so, which is probably the reason I'm not an attorney and especially not a judge. But we have to have a search warrant for that. Very, very important case. Did you want to say something, Kaylee?
Oh, no, you're fine. You can keep going. We just have a question in the Q&A about social media collections.
Okay, let me get to that in just a second here. So we have to be able to see how the criminal influence, the decisions of the Supreme Court are moving into the civil world. So let me answer this question, or Kaylee, do you want to field this question?
I mean, yeah, we can. So social media, we actually haven't had too many requests in the last, I would say 2 or 3 years for social media collections. We used to do it quite often, and we used a tool called, was it X1, Trent? Do you remember?
X1 Social Discovery.
X1 Social Discovery. That was the tool that we used, and it was fantastic at it. It looked just like the social media page, put everything there. It had deleted comments that it would have on like a Facebook picture of somebody or a post. If somebody commented and then deleted, it would show that it was commented, when it was commented, and then when it was deleted. It was a fantastic tool. We now currently use Axiom to do the social media, but like I said, we haven't had a request in a couple of years at least for social media archiving, but it is something that can be very helpful for certain cases. I will say though that like Facebook and Instagram and those two in particular really kind of tightened down on what the public can see. So you either have to have the person's Facebook account login information and their permission to collect their Facebook page and everything that goes with it, or you have to have, like, you have to be a friend of them or find a friend of theirs and have their login information to be able to see their posts. But like I said, if the person you're trying to collect the page from has like hidden posts from somebody, you won't see that unless you actually get their login information to collect their Facebook page. So what you can see publicly, it all depends on the user's security that they've posted or that they've selected for Facebook or Instagram, on if their posts are made public or not, on what you're going to be able to see. So if you're just going off of what's public, a lot of people don't make their posts public. They're usually private to friends, Sometimes it's down to only specific friends too for what they post. So you really do need access to the actual user's account when you want to collect it. As far as targeting government entities, we've not had that come across our desk to date, unless Trent, you know something I don't.
Nope, no, I don't. And one thing I'll say to that is we did see a spike in social media in relation to civil court cases. It was a few years ago, and it kind of was a quick opening wave and closing wave, because once those things become popular, you'll find companies like Facebook and Instagram specifically will make changes to their algorithms and the way that that information is gathered that makes it to where it can no longer be gathered. So we did see a really high influx. I think the most we ever did in 1 month, I think we collected on 25 or 26 different accounts in a single month. And then once it kind of died off, I mean, we probably haven't collected 25 social media accounts in the last 2.5 years.
I would say I've probably only collected 2 in the last 3.
Yeah, I would agree with that.
Another thing tying into that, like Facebook Messenger, it is not so easy to collect anymore. I used to be able to pull it directly off of cell phones, and Facebook, when they found that out, changed the way that Messenger works, and it no longer backs up. So we rarely get Facebook Messenger or Instagram messages off of cell phones anymore. That's going to have to be like a social media type collection moving forward.
Correct. You know, there's kind of a double-edged sword to a lot of the things that we do. My former business partner, his name's Richard Hickman, he did a research project when we were Decipher Forensics. And Richard quickly figured out that the very popular app Snapchat wasn't actually deleting pictures. And we thought this was really interesting information, because that was the whole claim behind the app, is that, you know, you're not able to recover these ever again. And it was very easy to recover these pictures that Snapchat was saying was gone. So we sat on it for probably a week or two, and we decided to do a press release, because this is something that can be used again from an evidentiary standpoint. We knew there was a lot of issues with different types of crimes being used, or Snapchat being used in conjunction with different crimes. So we did a press release, and if anything's ever gone viral in my life, that went viral, and I'd prefer it never happened again. I spent 2 weeks on the phone all day, every day, answering questions from media outlets, literally from around the world. And then what happened about 3 months after that is Snapchat changed its algorithm, and everything we just claimed that could happen became much harder to accomplish. Fast forward a year after that, it became nearly impossible. And we still get people that inquire with us about that. But recovering Snapchat at this point is something that we really can't do. In very desperate circumstances, people will still want us to do it, but we, try to be very honest with them not to get your hopes up about it.
Yeah. And I've been able to do it on some of the older iPhones. If they have like an older Snapchat version and an older operating system, but with the absolute newest iPhones and newest operating systems, I'm not getting anything from Snapchat, Facebook, or Instagram. So
correct. So if we fast forward, and thank you for that question, by the way, it's a very good question. If we fast forward and we look at the decision of Riley v. California, fast forward a couple of years, we have a change to the federal rules of evidence. And again, I don't cite the federal rules of evidence very often. In fact, this is about the only thing that I cite. If we look at 902.13 and 14, this allows parties to authenticate certain types of ESI without needing to offer testimony. One of the things that we used to do is we would go testify in court as to how we collected data. Now it should just be able to be done because of this through an affidavit, and don't have to testify, saves time, saves money. It's better for the client in the end. But if you read through those two things, 13 and 14 of 902, the data must be authenticated by a certification and by a qualified person. So a couple important things there. So this includes GPS data, cell phone, email, all types of electronic evidence have to be authenticated, and it has to be done by a qualified person. Now, I wish they would have been a little bit more specific than that, but they weren't. So the certification is what we equate to a hash value. And a hash value is what is referred to as metadata. Now, metadata follows you around everywhere you go, whether you're watching a movie on Netflix, whether you're texting, reading a Word document, looking at my PowerPoint presentation, reviewing an email. Everything electronic has a hash value. And all that hash value is, it's a mathematical calculation. It's an algorithm. And the most common hash values, there's actually about 35 different types of hash values. But in the world in which we work, the MD5, the SHA-1, and the SHA-256 are the most common. The MD5, which stands for Media Digest 5, is commonly not used as much anymore. It's typically the SHA-1 or the SHA-256. There's even a SHA-512 now that is being used more and more. But for example, if you have a 4,000-page Word document, and if I go to page 75 and I pick out the word "the," and I change the E to an A, and I save that Word document, and then I go back and I rehash it through some tools that we have, the hash value won't even look remotely close as it did before I changed the single letter in a 4,000-page document. This is why that's so important, because everything should match up when data is collected, when data is then used, and when the case is over, when an expert is done using that data, they should be rehashing that data to show that nothing has changed on it, to show that the data has not spoiled at all, there's been no tampering with the data. It's very, very important in the world in which we work, and this is why this portion of a ESI discovery request is so crucial. Now, the qualified person. Now, when I taught my course at Utah Valley University, and we'd get to expert witness, and we would run a mock trial, and for the attorneys on the call, you would have a field day laughing at me for the mock trial that I tried to run in this course. But what I would say about a qualified person or an expert, you're an expert if you're the smartest person in the room at the time in which the discussion is taking place. That is literally what the expert is. So I never put a lot of stock in the fact that someone said they're a court certified expert. That person has to be able to testify at trial regarding that authenticity, and they have to show the steps taken, as we've done here, and the tools used along with the chain of custody in how they handled the ESI that they were working with. So a couple things there that are really important. The tools being used, there's lots of different tools that can be used. But if that tool does not produce a hash value that can be authenticated by another expert, and if the steps that they present, if I have an opposing expert come to me and show me his report of a collection, and Kaylee or myself can't recreate those steps and get the exact same result using the same tool or a different tool, then we have a problem. It's the whole point behind the term forensics. Forensics is just simply a methodology that can be presented in court. Second to that, and this is where most people fail, it's in a established chain of custody. When we collect a laptop from someone, we want to know about this person: name, address, phone number, email, usually a driver's license number, or if we're here in the office, take a photocopy of their driver's license. This is establishing the custodian that we're retrieving this from. Second is information about the device itself: make, model, serial number, and there's some other information that we capture there as well. Third is, when did we take possession of it? Date and time, and then we show that it was released by the custodian and signed off, and then we received it at that same time. That's a standard chain of custody, and I've seen some very simple ones. I may or may not have stolen the chain of custody we use that we use currently from my time at the FBI. That may or may not be true. So the chain of custody is vitally important, because if I can't establish chain of custody, then again, that's just another bullet in my gun, so to speak, to help counsel. If they want that information removed from their case, it becomes an arguing point that this wasn't collected properly, and we can continue to move on from that point. So this isn't a polling question, but I want you guys to take a look at these two text messages. Please tell me which one of these is real. If we were in a live setting, I would be happy to have people just start blurting out the reasons why and raising their hands. But take a look at these and please tell me in your mind which one of these text messages is real, which text message is not real, and then why.
Feel free to use the chat feature to answer that question as well.
Oh, that'd be great.
Okay, we have, looks like Jesse says the left one is real. Brenda says the left one is real.
Interesting. Okay, mommy is fake.
Mommy is fake.
The left one is real. Okay. Left one is fake. Oh, I like this. Left one's fake.
In the Q&A, it says Bobby is real, left one real, left one is real.
Okay, so I think I'm going to say the majority of people probably think the left one is real. I love doing this. This is one of my favorite exercises to do. No one wants to answer. Very good. Okay, so here's the correct answer. They're both fake. I created both of those myself. Especially if you have an iPhone or know someone that has an iPhone, if you want to torment someone, go to iPhoneFakeText.com. You can create those exact same things. So both of those were fake. One of those was based off of a conversation of a friend that I have that I go backpacking with. And the other one was something I just literally made up out of my head. I've dealt with numerous cases where we have seen fake text messages. Sorry, Jennifer, that it wasn't fair. My apologies. We've seen fake text messages. About a year and a half ago, Kaylee worked on a case where a gentleman brought us his cell phone and he brought us his carrier cell phone records and bills. And to help us prove that text messages that actually got him landed in jail for 89 days were fake. And what happened, it was a domestic dispute, so to speak, but his soon-to-be ex-wife took text messages that actually took place, and using a website like this or something similar, there's a number of them out there, she decided to make the text messages worse than they actually were, and then she simply printed them off and handed them to law enforcement. Law enforcement read them physically on paper, not asking for her phone to properly take the phone and forensically pull the data, took everything at face value, went and threw him in jail for 89 days. Very successful businessman, lost hundreds of thousands of dollars in business during that time, almost lost his entire business. And as you can imagine, there's now a pending lawsuit from this gentleman to the municipality jurisdiction that threw him in jail based off of printed copies of something that was fake and they didn't take the time to investigate.
Right.
It's probably the most extreme. Go ahead, Kaylee.
I was going to say the court actually compelled her to send me her phone, and she factory reset it before she sent it to me.
And when you factory reset a phone, especially an iPhone, as this was the case, you're not getting any data off of that. The FBI is not, the CIA is not, and we're not. You're not going to get any information from that at all.
Yep. She completely wiped the phone. All of the data that would have proven that those text messages weren't sent or received to her phone, all of that was gone because she factory reset it because she knew she didn't do it. Correct. Or she knew he didn't send the text messages.
So this is an extreme version, but a real version or example, I should say, of why we do things the way that we do in criminal and civil cases for reasons just like this. So if I were taking a forensic image, which is just a fancy way of saying a copy of a hard drive or of a laptop, this is what a report that would get spit out from the software that we use would look like. Now, if you look at the top there, this was done by FTK Imager. That is a free program that anyone can download and use. You can see the version number. Up here, you can see my case number, my evidence number, that I'm the examiner, and then my notes were forensic image for preservation / analysis. As it collects the data, it's going to track all kinds of nerdy information that most people will never look at. But if you look about 2/3 of the way down there, the drive model is a WD. It stands for Western Digital, My Passport, USB device. So this is an external drive. We see the serial number. We see it is a USB interface. And then we see the sector count and other nerdy information. But there's those hash values generated, the MD5 checksum or hash value, and then the SHA-1. So if I hand this to an opposing expert, or if I handed this to Kaylee and said, please verify this, she should be able to plug it in, use a number. There's a whole plethora of tools. And when she verifies this, should get those two exact same hash values if this was done correctly. The other notable piece there is the acquisition start date and the finish date. You can see that this took place on January 26th at 9:16 and finished that same day at 3:24 in the afternoon. Very, very vital pieces of information from our standpoint when we're receiving information and data from opposing experts and opposing counsel. This is one of the first things that we go to, is to see when it was collected, how it was collected, and the tools they used to do so. So using the hash value, deduplication is fantastic. Obviously, when we're using and we're dealing with large swaths of data, we would like to deduplicate and get rid of as much of it as possible, so we're not reviewing the same documents over and over. That can be in emails and Word documents and Excel, whatever it might be. The most proper way to do that is through matching hash values, not because the two Word documents look exactly the same. If the two Word documents look exactly the same, it does not mean that they're the same. So if there's, besides a proper data collection, if there's one piece of information I can leave you with, and there's a reason I left this towards the end of the presentation. When Kaylee and I consult with counsel, most of the time they're only worried about what we call logical data. And we just refer to as what you see is what you get. If you can look at it on an operating system, then it can be pulled and used in court. What typically gets overlooked in civil litigation that doesn't get overlooked in criminal cases is recovering and using deleted data. I will tell you right now, if it were not possible to, as a blanket statement, recover deleted data, Kaylee and I would not have a job. It is at the crux of what we do and what we're asked to do most of the time when we're hired. If you're going into a civil case, and let's say, for example, the opposing side knows you're about to sue them, human tendency tells you to start getting rid of things. I mean, pull an Enron, for example, and start shredding documents, start deleting things, get rid of it because you don't want to get in trouble, or you want to mitigate the amount of trouble you're going to be in. So one of the things I will try to do fervently is talk counsel into requesting and collecting deleted data. The arguments back on that are, it's too exhaustive, it takes too long, it's an undue burden on my client, and I'm here to tell you, no, it's not. The difference between collecting logical data from an operating system and all data found on a hard drive is literally the click of a button. And let's just say, for example, on a standard 1 terabyte hard drive is probably the difference of about 2 to 2.5 hours, to pick as kind of a blanket statement. So there's not an undue expense, there's not an undue burden. It literally does not cost much more. And the opportunity cost is typically what is missed out on here, because we can find deleted documents. We can find deleted Excel documents. We once did a mortgage fraud case where 3 partners were trying to pin their criminal activity on the one partner that had no idea what was going on in his own company. And we were able to exonerate him and literally push everything back on 3 guilty parties and exonerate this man. And that was all done from deleted information from their computers. So it's a very real thing that in civil litigation is commonly overlooked. And that goes into the search methodology. Obviously in this, you have to have your meet and confer. You need to take a look at search terms and agree upon search terms and date ranges and things like that. But one of the things, again, that's commonly overlooked is making it very aware that in the collection of data, you want deleted data. You want what's called unallocated space. You want what's called slack space. And then the ability to search through those. From the standpoint which Kaylee and I work is not a difficult thing to do. It's very easy, and there's no argument for undue burden to the client, none whatsoever.
Also, Trent, we have a couple Q&As. Kristen wants to know, knowing what we know about cell phone forensics, do we use our cell phones differently?
I do.
So do I.
I do not ever attach to any Wi-Fi. I don't even attach to Wi-Fi at work.
Yep.
And your data plans are typically large enough that you don't really need to worry about how much data you're using, day in and day out.
Yeah, I have an unlimited data plan. I don't connect to Wi-Fi.
So that's probably the biggest thing that I do. The other thing is, like, I don't have TikTok because it's a well-known fact that TikTok bleeds information out of your phone. So I'm very careful about the apps that I use on my phone. And I don't have a whole lot left here, so I'm happy to just answer some questions. I don't connect to Wi-Fi, Jesse, because if I showed you how easy it was to hack Wi-Fi, you'd probably never connect to it again as well. It's any open Wi-Fi.
Also, how do we combat opposing counsel that is not tech savvy?
I usually help counsel do that by having very simple conversations with them. And a lot of times I will explain things just at a very, very, very root level of what we're doing. But honestly, when we're dealing with opposing counsel that isn't tech savvy, I use that to my advantage with my client. But there is a point in helping opposing counsel understand what it is we're asking for and why. And sometimes it's opposing counsel and the client that is not tech savvy. So it's not my job to hold opposing counsel's hand. But if we are trying to, get to a goal with opposing counsel, then I'm more than happy to do that.
And then Jeff Wyatt asked, how can Eide Bailly assist law firms with advising their clients when responding to discovery requests?
It's usually just done through a conference call. The discovery request is typically sent over to us. And then with the owner of the company or with the IT manager, depending on the size of the company and who's involved, it's just helping counsel ask correct questions so that we can collect the data properly and be in line with the discovery request at hand. But we do that on a regular basis. And I would say pretty much anyone in our industry, not just Kaylee or myself, anyone in our industry can do that very thing.
That's all the questions I see so far. Did you have any other slides?
The only other slide that I had really quickly is just metadata. Metadata is, this is the worst definition on the planet, is data about data. And a lot of times there's been numerous cases that I've been involved in where the metadata is more important than the document itself and what the document says. Things like the created date or the sent date. There's lots of information on the metadata. The hash value is considered metadata. A lot of this will help authenticate the document and its validity in a case. Again, just making sure that it hasn't been made up. So that's very crucial and important, again, in the proper collection of data. So that's all I had. I apologize for going over in time.
No worries. It was a great turnout, and we thank you all so much for attending. Thank you to our presenters. You guys did a great job, and we will talk to you guys next time.
Have a great day.
Thanks, everybody.